in the context of site allocations, boundaries which are shown on plans, and which can be described. In the circumstances of this particular settlement, there is no plan.
No, we know that, but I'm really following my Lord's question to you. I was wondering whether if we looked at the key diagram, we would see that there are settlements which have defined, i.e. delineated, boundaries on that map, whereas others don't. And that might assist in an understanding of how the concept of a settlement was regarded, at least in the case of those particular settlements. But maybe that's a false lead.
My Lord, I think there was within, that there is a plan at page 64. This is the new key into column community network area.
64.
But this does not relate to settlements. This relates to the community network area, which is a wider concept. There will be lots of different settlements included within that area.
Yeah.
That is clearly defined. But
well, for example, is the settlement boundary of Newquay defined anywhere on a map?
My Lord, I'm not sure that's an answer the question I could give any definite answer to. I think I'd have to take instructions on that. It is my understanding that there is not a series of plans setting out settlement boundaries within Cornwall. Cornwall is a vast area with dispersed settlements, and in the circumstances, it is my understanding that the council would approach each application with its own merits and consider what the settlement would be, if that is relevant to the application, on a case-by-case basis. The settlements may change, and the extent of the settlement would depend on the type of settlement it is. But it is my understanding there is not a set of plans which set out where settlement boundaries lie.
So the general picture in Cornwall is that most, if not all, settlements do not have defined boundaries on the proposal's map or key diagram or whatever it's called, but that therefore in the application of policy relating to the relationship between development and a settlement boundary, the boundary itself is a matter of fact and judgment for the decision-making authority to consider.
My Lord, yes, precisely that, and in the circumstances, it's a matter of planning judgment to be considered on any given application. That's not to say that officers do not express a view about it. They clearly did in the context of this case to some extent, at paragraph 23 of the officer's report. But it depends on the settlement concerned, which may change, and of course, a settlement which has some development of previously developed land adjoining that settlement would become slightly different after that development has been developed, so that the settlement boundaries may change over time. My Lord, looking at the next bullet point, under that dealing with rounding off and development of previously developed land, we have a reference to infill schemes, a completely different criteria here, but it is, I think, helpful to look at the wording of this paragraph and contrast it with that in respect of previously developed land, because it says that infill schemes that fill a small gap in an otherwise continuous built frontage and do not physically extend the settlement into open countryside. Proposers should consider significance and importance that large gaps can make to a setting of settlements and ensure this will not be diminished. So here the council decided that in respect of infill schemes, it is going to use more specific wording and use words such as physically in respect of the relationship between the site and the settlement. and therefore, this was a council not afraid to use more detailed wording. It could have used more detailed wording in respect of development of privacy development if it wanted to, but clearly chose not to. And in my submission, that demonstrates that the council was using wording which could have the wider ordinary meaning of immediately adjoining, and not the very restrictive meaning intended for by the appellant. Well, moving one step back and looking at the narrative around Policy 3, this starts at page 76 of the supplementary bundle. You can see at paragraph 152, towns and villages are central to the statutory. This is their role and function, not simply their size, that should determine the appropriate level of development to be planned for. And then 153, in order to maintain and enhance these places, the plan takes an approach to growth that encourages jobs and homes, where they best deliver our strategic priorities and allows for organic development, where it supports or enables the provision of appropriate services and facilities locally. Therefore, in my submission, this is making it clear what we're dealing with in Policy 3 is a positive, a permissive policy, not a restrictive one. It's trying to enable the delivery of the development of homes, and one which seeks to do so in a way which is organic development, which of course development of previously developed land adjoining a settlement would be. At page 77 of the bundle, paragraph 1.57, it says the majority of parishes that do not have a town or village named in Policy 3 can meet the remaining housing requirement through the following. And then the fourth point, the development of previously developed land within or adjoining settlements. There's not even any mention of immediately here. That's not to say that when one reads the policy statement itself, one should discard immediately. But in my submission, this does show that there is not quite the emphasis on immediately which the appellant is seeking the court to find. Then at paragraph 168, there is the definition of previously developed land, but the application of Policy 3, what it says about it there. In principle, the use of previously developed land within or immediately adjoining the settlement will be permitted, provided it is of a scale appropriate to the size and the role of the settlement. So going really no further than the policy statement itself, there is not in this narrative further text to say that the development must physically touch the settlement in some way. Had the council wanted to say that, it could have done here, but it didn't. And in my submission, all of this supports a positive interpretation of Policy 3, which allows for the ordinary meanings of the words to be given, not restrictive to contiguous, but also in the context of policy which is allowing the delivery of homes, which is seeking to achieve that. Again, with rounding off, above the words previously developed land, on page 78, in paragraph 168, there is further guidance in respect of that particular issue. This applies to development on land that is substantially enclosed or outside the urban form of the development, where its edge is clearly defined by a physical feature that also acts as a barrier to further growth, such as a road. It should not physically extend building into the open countryside. So very specific there, much stricter than the narrative used in respect of previously developed land. So in contrast, that is in my submission supports the judge's view that a restrictive meaning should not be afforded. the appellant refers to policy 7, and I tend to address that in due course. The threads also refer to policy 9. But, of course, there are many other policies in this development plan, including policies which are very positive in respect of the delivery of housing and development generally. My learned friend took Lordships to policy 1 at page 67 of the bundle. I do not intend to go through it again. Same as to note, this is presumption in favour of sustainable development. A policy which provides that applicants will, the council will work with applicants to find solutions which mean that proposals can be approved. Policy 2A is also, in my submission, very relevant to the interpretation of policy 3. It is at page 73 of the supplementary bundle. And that makes it very, very clear that the council will provide homes in a proportional manner where they can best meet the needs and sustain the role and function of local communities and that of the catchment. Development proposals in the period to 2030 should help to deliver a minimum of 52,500 homes at an average rate of about 2,625 a year to help deliver sufficient new housing for appropriate times to meet future requirements, in particular meeting affordable housing needs. So, targets for the council to meet, but minimum targets. My learned friend suggested that these policies were limited in number and limited in places. Well, in my submission, they're not limited in number. On the following pages after policy 2A, when we see the numbers for the relevant community network areas, this is not saying that the council will build that many homes and stop. What it is saying is it will deliver a minimum number of homes to the relevant area. Therefore, it's not a limit. It's a positive policy which seeks the council to meet its targets. And one can see at page 76 of the bundle that after policy 2A, after those key targets, one goes into the role and function of places, and then at page 78, policy 3. And in my submission, this shows that policy 3 is directly linked to policy 2A. It's all about delivery of housing. Policy 3 says how housing will be provided. And in that context, this is a positive policy. It is a permissive policy. It is saying that housing will be permitted in the circumstances set out in paragraph 3. Reference has also been made to policy 21 that appears at page 85 of the supplementary bundle. And this is about best use of land in existing buildings. And the statement says that to ensure the best use of land, encouragement will be given to sustainably located proposals that A, use previously developed land and buildings provided they are not of high environmental or historic value. So we know this is this case concerns an application on previously developed land. We know that we've seen pictures of the garage, no suggestion that the garage is of somehow any historical value. And of course we know there's no impact on the landscape. In all of those circumstances, what we have in policy 21 is a supportive policy for this development. And that is exactly what the council found in the context of the planning application in this case. Paragraph 24 of the emphasis report, so page 27 of the bundle. The council has grappled with and addressed policy 21 and concludes that this proposal was supported by policy 21 and that the site is previously developed land and in walking distance facilities and services to Bavarian, including a bus stop, school bus route, and a public house.
Sorry, where are you reading from now?
My Lord, at page 27, paragraph 24 of the officer's report.
Oh, sorry, back in the report.
In the circumstances, the council had decided that policy 21 was met, and indeed I think the summary refers to policy 21. At page 22, paragraph 2, the proposal was supported by policy 3 and 21 for local presumably meant to say So in those circumstances, it would, in my submission, be bizarre for the council to find that a policy which they considered was met and supported the proposal would lead to a restrictive interpretation of a different policy, which would lead to the potential result that the proposal would not be acceptable in accordance with that other policy. And the council's assessment and interpretation of policy 21 is not in dispute in this appeal. The other policy which has been referred to by the appellant is policy 9, raw acceptance side. That is at page 84. And that relates to affordable housing. It is not suggested that the development in this case concerns affordable housing. It is one dwelling in the interest of party garden. It is not an affordable housing scheme. In the circumstances, policy 9, in my submission, is wholly irrelevant to this planning application. Policy 9 cannot provide that policy 3 does not apply, or that it should be given some restrictive meaning. Policy 9, for the purposes of the planning application in this case, is wholly irrelevant. What is relevant when looking at a different policy, policy 7, is that policy 9 is expressly referred to in policy 3, page 79, as one of the ways in which development may be acceptable in paragraph 3. The last bullet point is raw exception sites under policy 9. So it directly refers to raw exception sites, affordable housing in that context. Policy 3 does not, however, refer to policy 7, which seems to be the key policy to which the appellant refers in support of their argument that policy 3 should be given the restrictive meaning they contend for. Policy 7, page 83, is a different policy from policy 3. It's addressing different issues. It has different criteria. You can see I don't intend to take Lordships through it in detail. I know the friend has addressed some of it, but we can see that there are five ways in which development may be acceptable under policy 7. Replacement dwellings, subdivision of existing residential dwellings, reuse of suitably constructed redundant or disused historic buildings, temporary accommodation for workers, wartime agricultural, forestry and rural occupation workers. So a very different criteria to that which is found in policy 3. And in my submission, an application could be supported by policy 3 and policy 7 in circumstances. But there may also be circumstances, and this case I submit is one of them, where an planning application is acceptable under policy 3, supported by policy 3, but it does not fall into one of the criteria in policy 7. The interplay between policy 3 and policy 7, I would submit, is this. Policies 7 and 3 are both capable of operating independently, and each capable of providing permission for development in the circumstances of the relevant case. A proposal may be supported by policy 3, and permission can be granted on that basis. Or it may be supported only by policy 7, and permission may be granted in those circumstances. The example of that might be in respect of agricultural and forestry occupation workers. It might be housing for that category is allowed on policy 7, but does not fall into one of the criteria under paragraph 3 of policy 3. There may, on the other hand, be a raw exception site or a rounding off or development of previously developed land, which meets policy 3 but does not fall into one of the criteria under policy 7. But if a development for housing in the countryside does not fall under one of the criteria in policy 3, then policy 7 would provide that there should be no permission unless it falls into one of the criteria listed there. And if it doesn't, then in those circumstances, the proposal would not be supported by the development plan. It wouldn't be supported by either policy 3 or policy 7. Any development of land immediately adjoining a settlement must be land which is outside of the settlement. Land outside of the settlement must be development in the countryside. Paragraph 2.33, the narrative to policy 7 on page 83 says that open countryside is defined as the area outside of the physical boundaries of existing settlements, where they have a clear form and shape. So, in those circumstances, it is very likely that any development, which is development of previously developed land, adjoining a settlement, immediately adjoining a settlement, whether using the appellant's interpretation or the interpretation the council contends, would be development in the countryside. In fact, would be development in the open countryside. It can't be the case that policy 3 requires every single application to be met by each policy, and they have different criteria. And an illustration of that can be seen by what is said in policy 3 in respect of infill, where it says that infill schemes that fill a small gap in an otherwise continuous built-up frontage and do not physically extend the settlement into the open countryside. So there's a reference there to extending into the open countryside. If policy 3 was always subject to policy 7, there'd be no need for that wording at all. In my submission, that wording is included because policy 3 provides an independent basis upon which development can be granted.
So which wording exactly in policy 7 do you say would not be necessary?
My Lord, I do apologise.
I'm sorry, I'm asking you which wording in policy 7 in particular would not be necessary if policy 3 was always subject to policy 7.
Well, my Lord, I suppose the way there'd be no need for the wording I'd say in respect of infill, the reference there to open countryside, if policy 7 just applied in every single circumstance, if an application had to comply with both.
Sorry, and which wording, are you saying there's wording in policy 3 that wouldn't be necessary, or wording in policy 7 that wouldn't be?
By the wording in policy 3.
Right.
So under infill, page 79, paragraph 3, it's the third bullet point down the top right hand side of the page. Infill schemes that fill a small gap in an otherwise contiguous build frontage and do not visibly extend the settlement into the open countryside.
Yeah. You said that the presence of those words makes it clear that 3 is not subject to 7.
My lord, yes. And there would be no need to include those words if 3 was always subject to policy 7. And if 3 was not capable of operating independently to provide permission in its own right.
I don't think anybody's submitting that 3 is subject to 7, because I asked Mr Humphreys this morning and he said no. Or at least I understood him to say no.
My lord, and in those circumstances, given that these are policies that are capable of operating independently, it is my submission that policy 7 cannot in those circumstances require policy 3 to have a different meaning to that which appears in policy 3, a more restrictive meaning. Because in those circumstances, it could be that policy 7 is, as in this case, was wholly irrelevant to the planning application. And if the policy is wholly irrelevant, then it would be, in my submission, it would be illogical for the wholly irrelevant policy to have the impact on the wording of policy 3 which the appellant contends for.
But the challenge is not on the basis, is it? This challenge before the court is not on the basis that the council mistook the relevant provisions of the development plan as not including policy 7. I don't think that's the thrust of the challenge.
No.
My lord, indeed, as I understand it, the appellant's challenge is that when looking at the words immediately joining in policy 3, one must bear in mind what is said in policy 7.
The essential challenge centres on the alleged misinterpretation and thus misapplication of policy 3. Policy 3. Doesn't it?
Indeed.
And the essence of it, which I think you've perhaps already addressed us upon, is that the council misunderstood its own policy as being less restrictive where it refers to immediately adjoining than in fact in context that policy must mean. That's the essential challenge before us. That is the point, I think, that we're confronted with. Not that somehow they also mistook policy 7.
My lord, indeed, in fact, the ground of challenge, as it was originally made, referred only to policy 3. It didn't refer to any of them.
I think that's what I'm saying.
It is in the context of interpretation of policy 3, to which those other policies, both policies 9 and policy 7.
What is said, to be fair, is that policy 7, and indeed also other policies, including policy 9, and I think policy 21, aid a true understanding of policy 3, because they provide the full context within which one must understand policy 3. I think that is why Mr Humphreys has taken care to take us to those other policies. That was my understanding of his submissions this morning.
My lord, in respect of that particular issue, the council's, as basically the starting position responding to that, the council says that policy 7 and policy 3 are very different policies. They're capable of operating independently. And in those circumstances, the context of what is said about developed and previously developed land in policy 3 is not informed by policy 7. It's policy 7 is a distinct policy, providing distinct, separate criteria for consideration of development in the countryside, which is not referred to in policy 3, unlike policy 9, which is. In my submission, there is nothing in the policy statement or narrative of policy 3 which links into it in terms of interpretation of what is meant by immediately joining policy 7, or the aims of policy 7.
Right.
My Lord, it is a matter which the learned judge addressed at paragraph 34. My Lord, in fact, later on in introductory, I think the key paragraph is paragraph 39 of page 81. Where the judge makes the point that the application of policy 7 cannot preclude the application of policy 3, where the development land is immediately adjoining the settlement. That would add a gloss to policy 3, which is not there, to include any development in open countryside, even if immediately adjoining a settlement. In my submission, that must be right, especially in circumstances here where the application does not involve any harm to the open countryside. That is something which has been determined by the council exercising its planning judgment. That is not challenged in this appeal. And bearing in mind that policies can be broad and may not necessarily always be able to be considered together at the same time, because there might be some conflict between them. In the circumstances of this case, there is no, in my submission, there's no justification for bringing in any aim of policy 7 to read the wording in policy 3. This is an application which the council found was supported by policies 21 and policy 3. At the start of the officer report, page 22, it's made clear that there's no departure, although the box is there, departure no, therefore suggesting the council did not consider there's any departure from the local plan. Not a case where the council considered that any policies were, there's a conflict with policy in respect of this development. Instead, this is a council which undeniably found that the application was in accordance with the development plan, considered as a whole. So looking at the wording of policy 3, narrative around it, and also the other policy considerations, in my submission there is nothing which requires policy 3 to be given the very narrow restrictive meaning intended for by the appellant. But also contend that the meaning found by the learned judge is a common sense and pragmatic meaning. That if a development could only be permitted under the relevance paragraph of policy 3 if the development touched the settlement, then that could lead to some bizarre consequences. There could be a development which physically touches the settlement in a very small way, but is otherwise very removed from it. There could be another development which is coexists with the settlement much better. It has a much more extensive relation with it, but is separated by 1 millimetre. In those circumstances, on the appellant's interpretation, that more extensive settlement, with more relation with the settlement, would not be permitted on the policy free, but the more removed development, which only has a small part of it touching the settlement, would be permitted. In my submission, that cannot be right. That cannot be what the council intended by providing this policy wording. Further, as settlements are not defined, as is a matter of planning judgment for the settlements definition, the boundaries of settlements to be considered on a case-by-case basis, that necessarily means that these are issues, whether something's immediately joining or not, and whether something is because something is not contiguous, it is immediate joining or not. All matters of planning judgment need to be considered by the relevant committee members on a case-by-case basis, using their know-all knowledge. There could also be problems in determining whether something is contiguous. One can see very unfortunate consequences where you have experts measuring the relationship between a potential development and the settlement to see whether it physically can touch it or not. In my submission, none of that can have been intended by the council or by policy free. The learned judge noted that there was a dispute of fact about whether the development site in this case was within the settlement or not. The council accepts that the officer report says that the settlement is separated from the settlement by a road. It's not challenged that the findings in respect of that issue. But in my submission, the judge did correctly refer to that in the context of disputes and uncertainty about whether something is immediately adjoining or not, the extent of a settlement. All of those matters require the exercise of judgment, which is why that ordinary broader meaning is required under policy free, not the narrow restrictive meaning contended for by the appellant. For example, the issue of whether a road is part of a settlement or not. That is a matter which, in my submission, should be considered on a case-by-case basis by the decision makers, with exercising the legal knowledge and hearing all the representations at the committee meeting about that particular issue. My learned friend referred to another issue in respect of policy free. The question as to whether the development itself, rather than the site of previously developed land, has to be immediately adjoining the settlement or not. In my submission, in the context of this case, it is not a distinction which takes the appellant's case anywhere, because the council has found, one can see at page 22 of the supplementary bundle, in paragraph 1, this is the officer's report, first page of it. It makes it plain that full planning permission is sought for the construction of a dwelling and garage on a site within the curtilage of an existing home nearby to the settlement Tribunals. So it is the site within the curtilage. please forgive me. I've lost my page references. If I could ask my lord, I could ask your lordships to turn up page 26. We can see at paragraph 21, the report says the site is located within the countryside. It is previously developed land by reason that it contains the garden area and the existing home on land outside of the field garden area. And further, the plans for the development itself, we can see at page 37, include the lane, include the garage, and include the land around it. That's shown in the red line plan. Therefore, the development site and the site of the previously developed land are one and the same. Therefore, there is no distinction to be made between the two.
Sorry, can you just run that again?
Yes, the site of the development and the previously developed land on which the development has taken place are one and the same thing. So there is no distinction in policy 3. It is, of course, the case that most homes are going to have some sort of driveway, some sort of lane or road leading to it, or some sort of garden. That's all part and part of the development. It is also the case that previously developed land will be developed in some way already, and it might be that the developer chooses to retain parts of that developed site and replace others. If my learned friend's contention is correct, and that the development itself must be contiguous with the settlement, that would raise, in my submission, that would raise bizarre consequences and would be unworkable. For example, what is meant by development? Under section 55 of the Town Project Planning Act, development can be the carrying out of operational development, but it could also be change of use. Is a lane or a garden or a driveway, which is in existence already, but used for a different purpose, a change of use or not? What does the appellant mean by the development? Does it mean the building itself? In which case, then a development would only be permitted under policy 3 if the building to be carried out were to actually be contiguous. But it wouldn't be if there was a driveway or if there was a garden. If the appellant means that the development means operational development carried out, and that must be contiguous with the settlement, then a developer could easily address that by, for example, building a gate or some kind of structure right up against the settlement. In all of the circumstances, it cannot be right that that the development itself, a building, for example, must actually physically touch the settlement, but other aspects of the development it cannot. That doesn't make sense in my submission in all the circumstances.
One could contemplate, could one, different examples, one of which would be that the building itself, as proposed, would have to abut, i.e. touch, the boundary fence or hedge of the neighbouring development which was in the settlement.
My lord, yes.
Or contemplate what might be the logical extreme of this, that the building had to abut the building next door, to be within the settlement?
My lord, indeed.
I mean, how would that work? How would that such a policy approach work?
Well, my lord, I suppose my answer to that is it cannot work, and that is the council's point. In circumstances, it cannot be right that the development to be carried out has to physically touch the settlement for policy free to provide it with consent.
Yes, but the question I'm really getting at is which part of the settlement? The garden of the house or the house itself? If the garden's in the settlement, but the garden on the other side can't be in the settlement, what is the correct practical approach? I'm wondering. Can you help us?
Well, my lord, yes. If
I mean, I know it's not your suggestion, but I'm just wondering whether, from the local planning authority's perspective, you can assist us as to how that might be made to work.
I think I suppose my first submission would be that it would, if my learned friend is right about this, then it would make policy free and workable and unnecessarily complicated and create confusion, which would be very problematic. On the other hand, if one looks at the meaning afforded to the words immediately adjoining by the learned judge and the way in which the council approached this application and approaches it in that way, then all that can be avoided because it's a matter of planning judgment whether something is immediately adjoining or not.
Am I right in understanding the proposition correctly? That even the less draconian version, just suggested by my lord, would mean that even if Treverian Hill was not the boundary or was not separating the site from the settlement, you would have to build the house at the entrance to the drive.
Well, that seems to be the appellant's submission. That development itself, the appellant, as I understand their case, is that the development itself must be contiguous, not the land which is previously developed land on which the development has taken place. And in my submission, that would lead to bizarre consequences and make the policy unworkable. The appellant may say, well, it's not just talking about buildings. It could be talking, for example, about a driveway or garden or something which adjoin the settlement. But in those circumstances, there would still be that would still be problematic in my submission. Let's say you have two scenarios. You have existing previous developed land, which includes garden, which physically touches the settlement. So on the appellant's interpretation, it would physically touch the settlement. But you have another situation where exactly the same property, exactly the same position, but what the applicant in that case is not. In one case, the applicant is going to reconstruct the garden. In the other case, they're going to leave the garden as it is. The land is previously developed land, so the garden is there already. One case they're going to develop the garden, the other case they're not. The garden would be very similar in either case. In one circumstance, policy 3 would permit it, in the other it would not, because the development would not be taking place adjoining the settlement. The development would be taking place away from the settlement. There would be a gap. That gap would be the garden. In my submission, that cannot be right. That there must be scope for planning judgment as to whether something is immediately adjoining, even though it's not physically touching the settlement boundary, even though, for example, it's separated by a road or it's separated by a hedge. There must be, in those circumstances, some scope for planning judgment to be exercised. I'm not sure my example about the garden was entirely clear, but even if the appellant is right about that point, then developers could easily get around the issue by developing right up against the settlement. It cannot be right that policy would encourage that. The appellant has suggested that somehow that this will create the decision in this case will create some precedent for other matters. In my submission, the facts of this case are very specific. Every application is determined on its own facts and merits, and just because the council has found that something which is not contiguous in this case is immediately adjoining, does not mean to say that it will not find that something else which is contiguous and not immediately adjoining. This case involves the specific facts which occur in this case, which are quite unique. Moreover, in other cases, any concern about development in the open countryside, affecting landscape, for example, would bring into play other policies which are not relevant in this case, because there was no harm to the landscape, as I said, and therefore would involve different policy considerations. So when the appellant says, well, this policy 3 needs to be very restrictive because it needs to protect the landscape, countryside, there is no issue about harm to the countryside in this case. If there was, different policy considerations would come into play. It would be a different assessment for the authority. So the appellant could be rest assured that the council would consider other policies which are relevant to any harm that would cause to the countryside if that occurs. The other point which I probably should address in respect of ground 1 concerns the decision of Gore. I have addressed this in some detail at paragraph 42 of my skeleton argument. I don't intend to go through the...
I mean, is there anything you want to add to what you've written there?
My lords, no, not to what I've put there. I mean, the primary submission is that case is concerned with secondary legislation. This case is concerned with planning policy. Different considerations apply. And the same could also be said of the Calhoun's case, to which my learned friend refers. That concerned a statutory context. There were specific issues in respect of how deemed development should be determined. I think it's also important to note that in looking at those cases and deemed development, of course, if one has deemed development, then there is no issue of planning judgment because permission is deemed to have been granted. Whereas in the context of planning policy, planning judgment is of course key. It is very important that the committee members can assess the different facts of the case against the policy. My Lord, those are my submissions in respect of ground 1. Unless there was anything else in respect to ground 1 your Lordships wish me to address.
No, thank you.
My Lord, I hope to address ground 2 much more succinctly.
Well, you've set out some submissions in your skeleton argument. So just pausing and reflecting. Do you want to add to anything you've written?
My Lord, no, the council says that this is a new point in response to my learned friend's suggestion that the point was raised in the court below. Council takes a different view about that. That's emphasised at paragraph 51 of my skeleton argument, where the two are compared. But despite all of that, the council position is this point doesn't take the appellant anywhere anyway, because firstly, as a matter of logic, if a proposal would extend the residential setting and function of Tribunal, rather than introducing a new home of a more detached nature, then whether one takes the appellant's interpretation of policy 3 or the learned judge's interpretation or below, as council says, is evident that approach was taken by the council. In all of those circumstances, if something is immediately adjoining, it is, as a matter of logic, going to extend the residential setting of the settlement. If something is a new home of a more detached nature, it's less likely to be immediately adjoining. And in any event, I set out some references at paragraph 56 of the skeleton argument. In any event, it is clear that this is a decision which is reached by the committee exercising their own judgment. They were not misled by the report, materially or at all, because they had been advised, firstly in the officer's report, that there is an issue of judgment and they have to reach that decision. They were told in, and I think it's actually the addendum that makes that perfectly clear, page 33, where the officer says a difference in opinion between officers and the parish council relates to whether or not the site is immediately adjoining settlement. If it is, a proposal can comply with policy 3 or local plan, but it would not if it is not. The officer makes clear that this judgment is arguable and sets out the reasons why officers have concluded the site is immediately adjoining a settlement. Make it clear it's up to the committee to reach a decision on that matter. And the minutes of the meeting also confirm that the committee did reach their own assessment of those issues. That can be seen from page 59. And your lordships have been taking to this. Councillor Fitter made the point that he considered that the Beacon House had always formed part of the settlement. But in any event, point 6, officers responded to members' questions and stated in paragraph 6, officers was of the view that Tribunal was a settlement and that the proposed site was immediately joining the settlement. The site of the proposed development was on previously developed land and could therefore be supported by policy 3 of the Cornwall local plan. The officers made clear that whether or not the site of the joining settlement is arguable, explain why it's arguable, and fight the committee to make their own judgments on this. And of course, they did make their own judgment on this because they discussed it in their debate, whether it's immediately adjoining or not, and then in the reasons given for their proposal, it is said, and one must take that as what the majority of the committee were voting for, the reason put forward by the proposer, that makes it clear that the new home would be on previously developed land immediately adjacent to the settlement. And in my submission, no material difference between adjacent to adjoining in that context. And therefore the committee reached its own decision. It knew it's a matter of argument. It had in its report and the addendum the comments made by the parish council, so it knew what was being said, but it reaches a conclusion with this. And in those circumstances, it cannot possibly have been misled by what's said in the report if what is states an obvious point.
Right.
Or unless I can assist, Georgia, so
No, thank you very much, Mr. Brett. Yes, Mr. Humphreys, your reply.
Lords, may I just begin in this way? We've heard a lot of, this is all a matter of discretion, judgment. We start off with a development plan. We should be able to apply that. Yes or no, does this accord with the development plan as a whole? If not, and we're not seeking to force it within the constraints, if not, it doesn't, that's not the end of the matter. It's whether there are material considerations that indicate that the determination should nevertheless be that planning permission be granted. So everything, there's a danger, everything's left to judgment, that then one ceases to have the rule of law, and one gets away from the primacy of the development plan. I know there's a proposal that we might do away with the primacy of the development plan and incorporate national planning policy as in its stead, but that's only a proposal out of consultation. But the importance of the present system is the development plan it is important. We understand it. And to be perfectly honest, standing back from this, one asks rhetorically, is it clear why the decision was reached and what on earth they meant by immediately adjoining? In my respectful submission, it's not. And it certainly doesn't apply those words, and the members of the committee aren't given a clear steer. Is it that they are being told that it's the proposed development, the house and the related garden, which is immediately adjoining, or is it being said it's the site because the site, the actual driveway, comes out onto Trevarian Hill? I want to go back as well to a point. An own friend raised issue of roads, and I want to go back to a question in that regard that Lord Justice Stuart-Smith raised to me earlier, which was in relation to, are you saying that if it was once immediately up to a road, then that's not immediately adjoining? And my submission was, because Trevarian Hill is accepted by the officer, implicitly by the committee, as not being within the settlement, and one understands that because it's a coast road, then for that particular circumstance, to be the wrong side of the road, and therefore outside of the settlement because there's a road between the settlement and the site, would not be immediately adjoining. If, however, this was if this were to be within the settlement, the road were to be within the settlement, then obviously having development on the other side of that road would immedially adjoin the settlement. There's one important point which I just wish to refer to in the policy, in relation to policy 3, and it takes us back to the wording for the page 78 of the supplementary bundle, the rounding off. It says that this applies to development on land that is substantially enclosed but outside of the urban form of the settlement, and where its edge is clearly defined by a physical feature that also acts as a barrier to further growth. Now, the B road is on any view a physical feature that also acts as a barrier to further growth. So one could round off within the settlement. But what we're looking for here is a physical feature that also acts as a barrier to further growth if one was going to round off within a settlement. There was some confusion as to what the planning statement put in by the planning applicant was referring to when they said, oh, the main road is a physical feature. This is rounding off. Clearly they misunderstood rounding off that section, because that has nothing to do, that physical feature, the B road, with rounding off here, because our coast road is the physical feature which is meant to be applied in rounding off, and the planning statement doesn't begin to address paragraph 1.68 in that regard. But what I wanted to come back to was in relation to this question of, oh, Mr. Humphreys, what does development mean? What are you referring to? My lords, I repeat what I said earlier, but I apologise for repeating it, but I thought at one stage, from what my own friend was saying, that I clearly hadn't made it sufficiently clear as to what my submission was. I am saying that one looks at the development proposal as a whole, and that is the built development. There is not a change of use in this case at all. There is no application for change of use. There is not a change of use. The site is already in residential use. There is no material change in use creating 3 houses rather than 2. So in terms of development in section 55, it's clear the development proposal includes the house, which obviously is the integral garage house, and also we can see that a garden on the plans themselves at page 38. The garden itself, page 40, at page 40 of the supplementary bundle, there is to the northwest of the proposed dwelling, there is to be a garden laid out, and that will require, what one can see from the aerial photographs, that will require removal of shrubs, digging, laying out, and the rest of it, all the sorts of things which will require diggers and levellers and all the rest of it to come in. So that is the development proposal. I do not say that the existing access drive is part of the development proposal. It's already there, and there's no physical change to it. So when we're dealing with policy 3, we say, does this development immediately adjoin? And we say, and just to repeat, we say immediate must be given some emphasis, must emphasise adjoin. If adjoin means adjacent, near to, immediately must, it makes it abundantly clear that it's not for putting off some setback, but it's immediate. Point of time, same, and immediate physically is it's right next to it. And therefore, if the development proposal shows a garden to be laid out with the house, and the garden goes up to the settlement boundary, or some physical features put in, and as a matter of fact and degree, one looks at it, one says, well, look, there's the house, the garden, there's you may be partly reusing a previous garden, you're redeveloping the site, for example. But yes, as a whole, that proposal is immediately adjoining the settlement, rather than being what I respectfully say is clearly from the photographs, not immediately adjoining. It's separated by a substantial area of over vegetated land, which isn't part of the garden, certainly isn't part of the curtilage of the Beacon House, and therefore is not in itself previously developed land. In terms of this particular access drive, Mr. Humphreys says that you'd have to put the house on the drive. Well, of course, that's physically impossible. That doesn't mean that therefore the policy is wrong. It shows that one's taking a narrow point that there's a driveway which, because of its existence, is previously developed land, and saying, oh, well, because of that, we can justify something yards or many metres away. If the scrubby area, if I may refer to that, to the north of the access drive, were previously developed land itself, then clearly one would be able to address the road. I'm not saying, as I've said before, because it's the coast road, and one doesn't want one's extending outside the settlement. That's the finding of the officer, that the eastern edge of that is the limit of the settlement. Thereafter, you've got a coast road, and beyond that, obviously not very far within, already 400 metres or so, you've got the sea. So so one can well understand why one's got to be very careful in saying that, oh, well, if it's just the other side of the road, it would be all right. Because you're outside of the settlement, it's just the sort of, it's not, there's no physical barrier, because a permanent physical barrier, you've gone beyond that, and you're not even immediately adjoining or right up to the settlement boundary. Nor, in that case, would you be right up to, even if it were on the west side, nor are you right up to the boundary on the western edge, nor are you right up to that side of the development. It's what one can get blinded, obviously, by the particular facts and look at the particular area of photograph. But in my respectful submission, the elements of judgment, the word immediately restricts the element of judgment. It must restrict the element of judgment. The element of judgment is to look at this development proposal as a whole, i.e. what is proposed as part of the development itself, physical and operational development here, and say, does that immediately adjoin, directly adjoin, in other words, physically adjoin the settlement boundary? And it seems to me it doesn't require any words to be substituted. It's to take the Braintree case, reminded at paragraph 27, it's the task, and this obviously in the Braintree case, my Lordship saying our task as council submitted is to construe the words, the policy itself, reading them sensibly in their context. This is not a sophisticated exercise, and it need not be difficult. It is, in fact, quite straightforward. Planning policies, whether in the development plan or in the NPPF, ought never to be overinterpreted. As this case shows, overinterpretation policy can distort its true meaning, which is misinterpretation. But, Lord, my point about the proposed development, even if one left that aside and one said the interpretation of policy 3, and I said, actually, one said, well, look, it's a question, let's go back to the words what to immediately adjoin. It's still the same point. It's still the same point, even if you take the view that it's the previously developed land which must immediately adjoin. Then, again, it's clear that that is not the position in this case. And in truth, the officer knows full well, in great respect, he says, it's arguable. Why does he say it's arguable? One can only infer because he knows it doesn't come up to the boundary. It doesn't begin to. He says this is separated by a road and by a driveway. He doesn't say, by the way, members, you ought to be, really, when we're looking at immediate joining, it's the development itself which you ought to be. It's just one paragraph 23, it comes in, whereas before it's about the site. He says, oh, it's separated from the site by a road.
You're coming very close to suggesting that the officer gave knowingly misleading advice.
Oh, no, I'm not suggesting it was, no, not in any way misleading. No, not deliberately misleading. I'm saying that if one understands what he's saying is arguable, immediately withdraw that if that was the impression I gave. I apologise. No, but in truth, what he was saying, if he were here to be asked questions, I think in all honesty, he would say, yes, it's arguable. I couldn't, I'm aware it's not up to the settlement, and because I know there's a road in the way, and it's not just the road, it's also that. But he doesn't develop that on to say to members, under Policy 3, this is the approach you should be taking. It's just, paragraph 23 puts everything in without explaining why he thinks it's only arguable, why it's difficult. Whereas the natural reaction would be to say, no, this doesn't apply with the development plan, but here are material considerations why we say planning permission should nevertheless be granted. And of course, just to answer another point, if this does not comply with Policy 3, it doesn't comply in this case with Policy 7 either. So there'd be 2 breaches of the development plan. I can see that in some circumstances, Policy 3 may be engaged, whereas Policy 7 isn't, although it's difficult because Policy 7 isn't just about the 5 special exceptions. It's also talking about development in the open countryside should not be permitted, or should be permitted only where. But I mean, it doesn't matter for present purposes. Present purposes, if this were to go back on the basis that they've misinterpreted Policy 3 and they say, yes, it's in breach of the development plan, they'd be saying it's in breach of Policy 3 and 7. And therefore, we need to look to see whether the material considerations which indicate why we should nevertheless grant planning permission. And the danger is that once you start substituting words such as near to or very near to, and they say, well, that was 70 metres away, 70 yards away, whatever it is, then every single time they can say, well, you've got to explain why in that circumstance that wasn't very near, and this one, or that was very near, this isn't. And it all comes into that unsatisfactory position, well away from London and the courts. I've practiced in this area for many years and been to many planning committee meetings. If I could just say this, of members being left to try to work out what on earth, to make a decision, whereas it really needs clarity of direction as to what the relevant issues are. And that's the danger that I perceive in this case. And it's not the precedent, yes, each case on its own circumstances, but the precedent here is not into it so much as, yes, it could be in its application, but specifically here it's in the interpretation that I'm concerned with. And that's all I can be concerned with, short of Wednesbury, perversity or unreasonableness. It's the interpretation policy. And I cannot get into the application policy unless in the application, underground too, that there's taking into account of an irrelevant consideration. So but first and foremost, I'm concerned with whether the interpretation policy is correct, whether that's been understood properly.
Well, do you, just to pursue that, to be absolutely clear so that we're clear what you're saying and what the limits of it are, are you acknowledging in that observation that if we were to take the view that the policy should be interpreted as the Council contends through Mr. Brad, that would be the end of the challenge and the appeal, because you could not then contend that the judgment inherent in paragraph 23, if we find that it was inherent in paragraph 23, was a Wednesbury unreasonable judgment?
The answer to that is no. The reason I say no is there'd be one extra point. One can't get into the Wednesbury unreasonableness point, but the way I've drafted it, the way it's been put before, I think, the way I've drafted it, say it's the last sentence or so of paragraph 23. Yeah. The test that's then applied, which is it's
ground 2. It's the ground 2 point.
It's the ground 2 point.
Yeah. Okay.
So that's separate from that.
No, I think understood. Yeah.
And just also to say, if I may, paragraph 37 of the judge's judgment, and judge at page 80 of the core bundle, the judge already understood the argument that I've repeated today midway through that paragraph. She said, as I understood it, the claimant's argument was rather that the policy in policy 7, prohibiting development in open countryside subject to very limited exceptions, could and should itself inform the reading of policy 3. I wasn't, it's not an error in the application of policy 7. I'm saying that one reads and looks at policy 7 to interpret policy 3, as my Lord Justice Lindblom referred. So that it's not, that was a point which the judge will also put to the judge. So I'm being consistent, I hope, with that, with the able submissions of Mr. Corbett. Yes, just a couple of points. There was a question about a field, a dispute as a field. Perhaps if I could just, in case there's any misunderstanding, perhaps if one looks at page, please, 38 of the supplementary bundle, the only fields that I can be looking at there.
I think that's Beacon House East, Southwest. Yes.
Very well. Well, the scrubby area, if I refer to that, or the vegetated area to the north of the access drive, is not the field to which reference was made. I suspect it was south of that area, whether it was that there's cone-shaped field, if I can just hold up. I suspect it was one or other of those pieces of land there. That's the best I can do to try and understand that as being between the settlement. But there's no question that no suggestion that other area is other than green field, so to speak, i.e. not previously developed land. I've a learned friend referred again to landscape. I make that distinction, important distinction, the difference between landscape and countryside, the character of the countryside. There is not a complete, just because one doesn't reach landscape policies of an area of great landscape value, doesn't mean that countryside itself is not, the character of the countryside is not relevant to sustainability. And that's why it's so important to protect the countryside unless there's good reason. Yes, take it back to Tesco on the policy 7, policy 3. That's policy 7 applies unless one falls within policy 3. I think that's consistent with what I said before. I think almost there. Let's see. Yes, I fully accept, that policies in the Cornwall local plan are looking to provide development. That's permissive. We need development. I'm not saying it's not a permissive policy, a positive policy. It's achieving growth. It's a minimum number of houses. My point was that out of the 4,800, 4,400 are in one specific area of strategic growth area centred around Newquay. The remainder of that vast area we've seen on the plan is a much lower number. There's a reason for that. A, because we should be putting the towns and the city, the main towns are the areas where we can cut our carbon emissions. It can mean that people have access to services without having to get in their cars. There's all the infrastructure which generations have paid into. It's there, which the vast majority of people can take advantage of. And that's why that happens. The rest of the area, they're very clear. We have this precious resource called the countryside. We're going to allow a certain, we're looking for a 400, it may be rather more than 400, but that sort of level. But what we're saying is we are directing it to specific locations, namely settlements, unless you are either within policy 7, the 5 categories, when you be outside the settlement for those, or there are 2 little points under policy 3, immediately joining on previously developed land, and or the rural exception sites. So that's why I say that it is in effect restrictive as to where that development should go, both to some extent in terms of numbers relative to the other areas, but also in terms of location for that 400 or a minimum of 400. I think, oh, that's, yes, my own friend referred to the policies encouraging development where it can be best delivered, and that's entirely consistent with it's the right homes in the right places. It sounds like a political slogan, but it's a plan. It's good planning. It is in the right location. It's not just anywhere. That's the, if I may say so, the real issue which lies at the heart of our planning system at the moment. It's of course, but that needn't trouble the court. But anyway, I just mentioned that. Would you forgive me just one moment?
Of course, yeah.
Lords, unless I can assist your lordships further, I'm grateful.
Thank you very much, Mr. Humphreys. Well, thank you both very much indeed for your very clear submissions, both written and, of course, oral. It will not surprise you to hear that we shall reserve our judgments. Drafts of the judgments will be handed down and will be provided in due course prior to hand down for typographical and minor factual corrections only. At that stage, the parties should endeavour to agree a draft order for us to consider, and should at the same time please submit to us any submissions made on the basis of any disagreement as to the content of that order. In other words, the normal arrangements apply. Thank you all very much.